On January 6, 1999, in Port St. John, Florida, the body of 29-year-old Sonya Nicole Speights was discovered lying in a blood-drenched tub. Investigators were initially informed that it was the site of an accidental shooting, but the evidence indicated something far more suspicious. Who was this woman, and who was the monster who murdered her inside her home? Hello, and welcome to Shades of Murder. I am your host, Alita Caldwell. In this podcast, I discuss cases of murder from around the world and throughout history, attempting to unravel the layers of darkness that help make humans into monsters. This show contains specific and at times very graphic and disturbing details of the case. This show is not intended for all audiences, and listener discretion is strongly advised. This is a special warning for those of you who may be especially sensitive to crimes committed against children. I present to you the heartbreaking case of injustice about brother and sister Catherine and Curtis Jones, who at the time when these events unfolded became the youngest convicted murderers in the United States. No one listened. No one did a damn thing to help this little girl, and the abuse just kept happening. Catherine felt helpless and isolated, but decided to take back her power after one particularly horrifying incident with her offender. One day, while she was in the shower, she heard the bathroom door creak open. Catherine wasn't alone. He ripped open the shower curtain and watched her, touching himself. The girl cowered in a ball on the floor of the tub, crying and covering her eyes as he masturbated in front of her. Then he put 50 cents on the toilet seat and closed the door behind him. That night, young Catherine Jones wouldn't eat her dinner, and she withdrew from everyone. She went to her bedroom and wrote in her journal, "I'm going to kill everybody." The girl admitted later that night what had happened to her brother Curtis, and that she wanted their abuser, their father, and their stepmother dead. Curtis offered to help his sister get rid of them all. Together they came up with a plan to sneak into their father's bedroom and take his 9mm semi-automatic gun. The tortured young brother and sister had had enough. Documents would later be unearthed that proved there had been allegations of sexual abuse made, but the organization, which is now called the Florida Department of Children and Families, for reasons unknown, had chosen not to investigate further. There were also documented claims of abuse by the sheriff's department. Their father and stepmother didn't believe them. When the last people Catherine Jones hoped would come to her and her brother's rescue failed to help, she knew it was up to her to take control. So the young girl began to plot and plan the murders of her abuser, her father, and stepmother. She labeled it in her diary as the kill list. On January 6, 1999, in Port St. John, Florida, the tortured brother and sister were ready to set their plan in motion. The children sat at the dining room table while their stepmother, 29-year-old Sonya Nicole Speights, was invested in working on a 500-piece puzzle. Their father was out that evening, and their abusive relative would be home later that night. Curtis held their father's gun in his lap at the opposite end of the table. The first bullet shot her in the chest. He kept firing, missing Sonya with some, others hitting their target. Catherine fired the last 2 bullets until Sonya was dead. They had done it. They had killed their stepmother. But now, what were they going to do? Curtis became hysterical. He was shaking and uncontrollably. Catherine did her best to calm him down. Together they dragged Sonya's body across the room and placed her into the bathtub. They poured bleach all over the carpet and floor, but a large trail of blood was left behind. The kids realized they had screwed up big time, and they had to do something to fix it. Catherine and Curtis ran from one friend's house to the next, saying that they had accidentally shot their stepmom. One of their friend's parents overheard and insisted on contacting the police. Things were not looking good, and the brother and sister knew they had to leave. Catherine and Curtis ran to the woods near their home to hide. They slept there overnight, helpless and terrified about what they had done. When officers arrived at the Jones residence, they found Sonya Nicole Speights dumped in the tub in a pool of blood. The woman had been shot 4 times. There were signs of an attempted cleanup of the crime scene, which began in the dining room and ended in the bathroom. It didn't seem likely that the death was an accident. The next morning, law enforcement investigators located the 2 children. When the children were captured and arrested for murder, no one asked them what had happened and why they wanted their stepmother dead. Instead, the sheriff announced to the media and the community that the children were jealous of their stepmother taking their father's attention away from them, and they wanted her out of the picture. According to the Orlando Sentinel, Brevard County Sheriff's Agent Todd Goodyear stated to the press the motivations of the young killers were simple, and I quote, "At one time, they had been a trio, sort of like the Three Amigos. Now they were a foursome, and they were resentful and jealous of the fact." How absurd and unprofessional that law enforcement officials would make such a statement. And the prosecution proceeded to paint these children as having murdered their stepmother because it used to be the 3 of them, and they wanted her gone. There was no evidence to support this, except that no one attempted to help these children understand what was at stake and how the legal process works. Catherine and Curtis Jones were terrified young children, and they had no idea how to handle criminal proceedings. It should have been obvious to the prosecutor and their defense attorney that for these 2 otherwise good, obedient kids to have committed such a violent crime, there had to have been a serious reason. A reason that could have presented mitigating circumstances in court. But no, neither side did anything to learn about what these children had experienced. They made no effort to support them or try to understand how these children, neither of whom had any history of deviance or violence at all, shot to death their stepmother. Catherine Jones' attorney, Kepler Funk, even stated that previous abuse is not a defense for first-degree murder in Florida, unless the defendant was facing imminent danger and was acting in self-defense. Under these circumstances, Catherine and Curtis Jones felt they were in constant danger, and in their young, desperate eyes, it was an act of survival. The extent of the abuse was never asked about, though, and Catherine and Curtis were too petrified and untrusting of adults to share their story. They believed from experience that no one would believe them, and maybe it would make their situation even worse. The prosecution labeled these 2 kids as monsters and charged them as adults. Catherine was 13 years old, and Curtis Jones was 12. They were indicted on charges of first-degree murder by a grand jury. Under Florida state law, if they had been charged in juvenile court, they would have been released in 36 months. But now these 2 children were facing life imprisonment if convicted. I have no doubt they were strongly influenced, if not pressured, by both sides of the court to admit guilt and come to an agreement. Catherine and Curtis Jones admitted to shooting Sonya Nicole Speights and accepted a plea deal for second-degree murder. Since a plea deal does not offer the opportunity for testimony because there is no trial, there was never any chance to show documentation from the Child Welfare Agency in addition to the sheriff's office that they had been victims of sexual abuse. If they had gone to trial, the evidence provided by the departments would likely have forced the prosecution's hand to lessen the charges. During the court hearing, Catherine Jones expressed sincere remorse and regret to the judge, telling him, and I quote, "Sir, there was no reason to do it. I may have thought at the time that it was, but there was no reason to take another person's life. This 13-year-old girl conveyed maturity and understanding of her actions beyond her age, yet her words didn't make any difference." The judge sentenced them to 18 years of incarceration and a lifetime of probation. Catherine and Curtis Jones had officially become the youngest children in the United States to be convicted of murder. Their father, Curtis Sr., stood by their side throughout the entire process. However, there is no information on whether he ever owned up to his part in this tragedy. The children hysterically sobbed in court upon hearing their sentence. As they were about to exit the courtroom, 12-year-old Curtis Jones turned to his attorney and heartbreakingly asked if he could bring his Nintendo with him to prison. This statement, so innocent and symbolic of a child's mind, should have been evidence enough. The justice had gotten it wrong. It was learned years later that the department had documentation of signs of sexual abuse inflicted upon both children on multiple occasions. Years earlier, child welfare agents had looked into the claims of a family member sexually abusing both children. The first investigation into the child's welfare was in 1989, shortly after their mother left. Their father, Curtis Sr., was arrested for shooting 2 men at a pool hall in Titusville, Florida, and was charged with attempted second-degree murder. These charges were later reduced to a misdemeanor when it was determined that the crime was an act of self-defense. At the time, Curtis and Catherine Jones were living with their paternal grandmother in Alabama. Around the same time period, a family member who was a convicted armed robber decided to move to Titusville, Florida. In 1993, this individual was also arrested and convicted of having sexual relations with a 14-year-old girl, who was the daughter of his then-girlfriend. Curtis Jones Sr. allowed this monster to reside in his home with his 2 young, vulnerable children. Not even a year later, Curtis, who was only 8 years old at the time, told his mother while visiting her in Kansas that this person had molested him. At the time of the incident, Curtis reported to the sheriff's office in Florida that this man shared his bed with him and sometimes fondled him. Unfortunately, when Curtis returned to Florida, his story changed. He said he had made it all up because he wanted the man to move out of their home or hoped he could stay with his mom in Kansas. Based on this, the agency closed the investigation, but it wouldn't be the last time the Jones family was looked into. In 1996, they had investigated abuse allegations when Curtis Jones was seen with a bruised and swollen eye. In September 1998, 13-year-old Catherine ran away from home. According to documents, a teacher at her middle school had informed child welfare workers that she suspected Catherine was a victim of sexual abuse from someone living inside their home. Not wanting to face punishment for running away, she denied the teacher's claims and returned home. Investigators offered parenting and counseling services to the family, which her father declined. Catherine admitted later that her father was the one who had intimidated her into lying about the abuse. Investigators warned her father that the person she had accused of abusing her was the family member living with them. They told him that he shouldn't be there with children since he was a convicted pedophile. How could a father invite such a man to live in his house? Then would not just one, but both of his young children claim this person has been sexually abusing them? He calls them liars and doesn't do a damn thing to stop it? Where's the justice for his inaction and his revolting lack of concern regarding the safety and purity of his children? He chose the side of this vile family member over his kids. Curtis Jones Sr. is the one who should have been thrown in prison for 18 years. These children were victims of severe sexual abuse, and the adults in their lives didn't believe them. Sonya Nicole Speights was not abusing them, but in their young, traumatized minds, killing her, which was supposed to be the first of 3 murders, was a way to end the cycle of abuse. It was an act of self-defense and self-preservation. There have been many cases of homicide where a victim of abuse finally acts out in self-defense and kills their offender. Although some have faced severe penalties, others have been sentenced to little to even no time in prison. Studies indicate that as high as 80% of adolescents who are given life incarceration are victims of sexual or physical abuse. Instead of protecting and preserving the lives of these young victims, they are further traumatized and punished by the system. Less than 4 months before Catherine and Curtis Jones murdered Sonya Nicole Speights, the Child Welfare Agency had documented signs they were both being sexually abused. Yet somehow, it was not further investigated. Officials elected to stop pursuing their case. I don't understand how these gross injustices can happen to children because child welfare agents decided to close the case. How is it even legal to not investigate further when there were multiple documented signs of sexual abuse? Court records on the alleged offender show that he had been convicted of sexual assault against his girlfriend's daughter, who was a minor in 1993. You would think that knowing this monster was not only living with 2 young children, but sharing a bed with a young boy who had accused him of sexual abuse was enough of a reason to pull these children out of the home. Their mother, Stacy Parks, abandoned her family when Catherine was 4 years old and Curtis was 3. In later interviews, she claimed she had no choice. According to her, she suffered from extreme domestic violence at the hands of Curtis for years, and she couldn't deal with it any longer. Her husband had violently beaten her from early on in their dating, and she became pregnant at 17 years old. The violence did not stop, though, and Curtis beat her even when she was pregnant with Catherine. As a result, Catherine was born prematurely. Only months after getting married in 1989, Stacy pawned a gold chain for a one-way ticket to Kansas, where her mother lived. Curtis had made it crystal clear that he wouldn't let her take the kids away from him, and her mother was a racist who didn't want her biracial grandchildren to live with her. In 1993, Stacy Parks returned to Florida and pulled her children out of school. She ran away, taking them to Kansas, but she was arrested on charges of interference of custody. Curtis and Catherine were promptly sent back to their father. The charges were dropped, and Stacy never attempted to take her kids away from him again. I will do my best to refrain from being overly judgmental toward this victim of domestic abuse, but how could a mother willingly leave behind her small children with a man who violently beat her? How can a woman choose to live with her racist mother who refuses to welcome in her grandkids because they are half African American? She prioritized her own survival and not her kids' welfare. Stacy Parks has expressed that she thinks her children's lives may have been saved by killing Sonya Speights. Or maybe this tragedy could have been prevented had she put her children first and fought for their safety over her own. From the beginning, everyone in these kids' lives had failed them, and the system would continue to do so. The courts never demanded that the Child Welfare Agency provide any answers as to why it failed to protect these children. They had acknowledged in written documentation that there were signs of sexual abuse against both kids, yet they were not held liable for closing the investigation. Again, I ask, how is that legal to do? How does an organization have that kind of power over the safety and well-being of children's lives, fail miserably at doing their jobs, and are not held responsible? This is disgusting, and unfortunately, this is not the first or the last time these child welfare departments have shown to be grossly ineffective and irresponsible, leading to further abuse and neglect of children, and sometimes even their deaths. How is there not a system in place overseeing these departments to hold them responsible for their actions or lack of? It wouldn't be until 2009 when Catherine Jones finally spoke the truth about what events triggered the murder of Sonya Nicole Speights. In an interview with Florida Today, she shared how she and her brother were being sexually abused by a family member who was living with them. When they told their father and stepmother that he was sexually molesting them, neither of them believed the children. Catherine openly said that she regretted killing her stepmother, but how she was also so relieved that she was away from an abusive home. Isolated in prison, Catherine finally felt she could breathe away from her abuser, and she found comfort in that solitude. She wasn't safe, though, inside an adult prison. When she was 15, she was sexually assaulted by a correctional officer. It wouldn't be the last time Catherine was abused, as this child was placed in an environment full of new predators and pedophiles. Studies show that youth who are placed in the adult prison system face higher rates of mental health problems, including suicidal ideation, and suffer from abuse by fellow inmates and guards. Many children are isolated in adult prison to prevent them from being harmed by the general population, but these effects can be even more devastating to their development and mental health. Although she did find solace in the isolation, Catherine also was traumatized by her actions. She suffered from endless nightmares, and her mental health suffered greatly. But no one was there to help her. No one was there to talk to this terrified and traumatized child. Once she got to the point of trying to take her own life, a counselor came to her after she was placed on suicide watch for 72 hours. It wasn't that there was a problem necessarily with this counselor, but the lack of mental health resources inside the prison was appalling. For the almost 3,000 female prisoners, there were only 3 counselors amongst them. Catherine Jones initially didn't walk a straight path, surrounded by criminals with no one to tell her that she counted, that she mattered. She found herself in constant trouble. That is until pastors Betty and Charles Williams entered her life. The couple had established the nonprofit Fresh Start Ministries of Tampa and taught classes at female prisons. They were tough on Catherine at first. They were critical of her choices, made her look at herself and where she was headed. Betty and Charles Williams told her she was a leader, but not in a good way. But she had the chance to be, if she chose the right path. They fundamentally changed who Catherine Jones was to herself and to her fellow inmates. She helped heal herself by helping other victims of sexual and physical abuse. Catherine became a mentor to the inmates, even creating her own curriculum to help women heal and find their unique purpose. The Williams became the closest thing Catherine Jones had to family. They embraced her as their own, and Catherine today lovingly refers to them as her parents. Now she gives back what Betty and Charles Williams gave to her. Catherine Jones has been very vocal in the media. She has been openly willing and anxious to share her story and her life experience before and after her incarceration. But her younger brother Curtis has been the opposite. Florida State University law professor Paolo Anino, who has advocated for years to achieve clemency for the siblings, publicly declared that Curtis does not want him to comment on anything regarding him or his situation. Catherine seemed to embrace her penance and felt she was where she needed to be. She used her time in prison to heal the best she could from her abuse, and in time found inspiration and hope. While Catherine was imprisoned, Navy Senior Chief Remus K. Fleming heard her tragic story and felt compelled to write to the young woman. The two created a strong connection, and Remus began visiting her in prison. Catherine and Remus fell in love and married on November 27, 2013, in the chapel at the Hernando Correctional Institution. Unfortunately, her brother Curtis initially only made his circumstances in prison worse. In 2004, he and several other offenders attempted to flee the facility. It was during Hurricane Francis, and the storm had knocked down the outer fence. The kids ran for it, but they were captured 24 hours later. His actions led to an additional 318 days being tagged onto his sentence. Over the years, he grew more mature and grounded, which I'm sure was in part due to the support he was given. His father, his mother, his grandmother, one of his cousins, and some of his old friends visited him regularly in prison. Ever since 2008, Curtis Jones had refrained from being involved in any trouble. Then the young man found himself drawn to the Christian faith, which deeply changed him. He became a religious leader and mentor to fellow prisoners, and is now an ordained minister. And so, almost 2 decades pass, and the world moves on without Curtis and Catherine Jones. While the sister and brother sat in prison cells, society changed in vast and profound ways. Think about the advancement of technology alone during this period, from smartphones, virtual reality gaming, social media, and AI. The world is a strange and frightening new place for these kids who are now adults to enter. Along with the drastic evolution of the world around them, they are also faced with the lifelong label of being murderers and have to deal with lifetime probation. How and why, I wonder, is lifetime probation even permitted by the courts? It seems excessively micromanaging, not to mention a waste of precious resources. This literally means their probation could be revoked and they could be sent back to prison if they do anything that violates their conditions at any time during the rest of their lives. Talk about a perverse sense of freedom. You are no longer held in a cell, but you always have to answer to the system, no matter how much you have atoned, no matter what you've accomplished, no matter how old you become. A huge challenge long-term incarcerated offenders face after being released from prison is the concept of choice. This rings even more true for a young person who has grown up within the system. It is not easy for most of us to conceive, but when the system dictates what you do, what time you eat, go to sleep, or at least must remain in your cell, and controls all imaginable options of food, drink, exercise, and forms of entertainment, being faced with the opposite can be debilitating for some. The idea of being able to do what you want when you want within the parameters of the conditions set by parole has been reported by many released offenders to be overwhelming, anxiety-inducing, and even traumatic. These children have had little to no relationship with the outside world, so adapting to this new environment as adults and the possibility of free will and choice will be especially tough for them. There are also the strict life-restricting conditions of life parole. Some of these include $50 every month for the cost of supervision for the first 18 months. They are not allowed to use intoxicants excessively. What that entails exactly, I don't know, but I presume it means that they can't ever be tested within above the legal limit for alcohol and obviously no kinds of drugs in their system. They are not allowed to relocate before consulting with their probation officer and a dozen other conditions. The brother and sister do have the right to hire an attorney to pursue early termination of their probation, or at least to modify its stipulations. The Florida Department of Corrections currently has a 3-phase approach to handling the basics of adapting to freedom, and with the goal of not returning to prison, of course. The first is getting ready, the second going home, and the third is staying home. 6 months before an inmate's scheduled release date, a transition plan is developed for them. This includes housing, employment opportunities, family reunification, and the continuity of mental health and/or medical care. The process of reentry is designed to begin 3 years before, with the final 6 months including 100 hours of classes where they are taught how to use a computer, a cell phone, the principle of money management, and career assessment. Upon their release, they are provided examples of resumes, ways to market themselves that can encourage employers to hire an ex-offender. Now, whether or not this approach is executed properly and with any positive impact, only the prisoners could attest to. It sounds good on paper, but only if they have legitimate mentors to help them navigate these drastic changes in life will they successfully avoid reoffending, also known as recidivism. Catherine Jones was 13 years old when she was arrested and was 30 when she was released in 2015. Her brother, Curtis Jones, was released earlier that same year. She continues to be an inspiration to others, following the path she refers to as her life of redemption. In her words, "There's no justification for taking someone else's life. In my 13-year-old mind, I could have gave you a bunch of reasons of how I felt desperate. I felt hopeless. I felt trapped and angry and bitter for everything that happened to me, but nothing justifies what I did. I wouldn't even try to." That she owns up to that speaks volumes to her character. I think it is just another indication of how wrong the system was and how they treated her and her brother, but she doesn't seem to hold any grudges. Catherine is also a mother to a young son and daughter, and she sees it as her mission to help make society better for their generation. She doesn't take her freedom for granted and actively helps her community, even working aside people within the criminal justice system. As a member of Orange County's Citizens Safety Task Force, she is one of over 30 individuals composed of officers, prosecutors, pastors, and community activists. Their mission is to help prevent violence in their community, especially among the youth. Catherine is also one of the county's credible messengers, who are individuals who use their personal life experiences to help mentor the youth. She is also dedicated to reforming the laws that led her to losing her entire childhood in prison. Catherine worked for the Campaign for the Fair Sentencing of Youth, which seeks to end life imprisonment for youth without the chance of parole. Although federal legislation states that a youth can no longer be given a life sentence without parole, there are still some exceptions being made in the states, Florida being one of them. Florida is amongst the top 5 states in the U.S. that sentence youth to life without parole. More children are prosecuted as adults on felony charges in Florida than in any other state, and the majority of these juveniles are Black. Many individuals in our society choose to believe that systemic racism in the criminal justice system doesn't exist, but research shows otherwise, and it is not limited to adults. Extensive data shows that it is present in all stages of the process, from arrest to punishment. Children who are of African American or Latino heritage are more vulnerable to being targeted and are more harshly treated by law enforcement, prosecutors, and judges. Racial and ethnic minorities who commit crimes face a higher likelihood of being arrested, have a greater chance of being charged and prosecuted, and when sentenced, receive harsher penalties than their white counterparts. Data collected from the Justice Department further supports racial disparities in the law. But first, let's step back and discuss the origin and purpose of the juvenile waiver. Juvenile waivers began in 1966 when the Supreme Court rejected the argument that the core ideals of rehabilitation justified arbitrary procedures in the case Kent versus United States. In other words, juvenile offenders have the same right to due process as adults. In Rigault, 1967, the court granted juveniles the right to counsel, protection against self-incrimination, and the right to confront and cross-examine their accusers at a hearing. During what many would consider to be some of the most violent decades, youth in the late 1980s and early 1990s committed an alarmingly high amount of serious crime. Violent crime, including aggravated assault and murder, increased by 68%. Many began to ask and wonder, especially those within the criminal justice system, whether juvenile courts and associated punishment were enough of a deterrent and a suitable penalty for some of these offenses and offenders. It was during this time that more juvenile transfers to criminal court would occur than any other decade before and since. One of the primary purposes was to prevent reoffending by the juveniles once they were released, but the data has shown to be the opposite. A study conducted on juveniles transferred to adult courts in Florida and rates of reoffending showed that the results were very concerning. It found that juveniles waived to adult court were significantly more likely to reoffend. More alarming was that the crimes they committed were more serious than those committed by juveniles who were dealt within delinquent or juvenile court. All 50 states and the District of Columbia currently allow juvenile transference to a criminal court by one or more methods. These can include a judicial waiver, the most common mechanism, and grants a juvenile court judge the power to waive a case to adult criminal court. Others include direct file, which gives the prosecutor the power to file criminal charges directly against the juvenile, and statutory exclusion, which mandates juvenile prosecution in adult court for certain kinds of offenses. Some states currently have laws that prevent adolescent offenders from being handled by juvenile court in the future, once they have been waived. The majority have what are known as statutory exclusion laws that mandate certain types of crimes be handled in adult court. 18 states currently have this legislation. Another 10 allow, and 12 states mandate that a judge order a waiver to criminal court if an offender was adjudicated as a delinquent in the past. In other states, the prosecutor may file charges directly in criminal court against a juvenile who is 16 years or older who has committed any felony, a juvenile 14 years or older who commits a violent felony or burglary, and a juvenile of any age who commits murder. Some states have set a criminal age of responsibility, which mandates that children as young as 16 years old be waived to criminal court. Juvenile court judges are also given the power to waive any juvenile who is 14 years or older under similar circumstances. Although the number of juvenile cases waived decreased by 53% between 2005 and 2015, these new laws and mechanisms that bypass the juvenile system have created cause for even greater concern. Youth who are waived to adult court face crippling stigma. They are treated more criminally culpable, less redeemable, and are perceived as being more dangerous compared to their adult counterparts by the prosecutor and the court judge. The National Juvenile Court Data Archive, collected by the Office of Juvenile Justice and Delinquency Prevention, presented the following data. The percentage of juveniles being charged and tried in criminal court is extremely rare, with an average of less than 1% each year. However, Florida leads the country, and direct file mechanism is its most common practice. The direct file involves the authority given to a prosecutor to charge juveniles as adults without requiring review by a judge. During the mid-1990s, which was the height of its practice, almost 5,000 juveniles were charged as adults, which was more than 10% of its total youth offenders. By 2020, the number had dropped to its lowest in history, declining 77%. The research shows that racial and ethnic minorities, older adolescents, and males are much more likely to be waived to criminal court than females, whites, and younger offenders are. Black males face the highest risk of being waived, followed by white males and then black females. 27% of all charged juvenile offenders in Florida are black males, and they represent more than half of the juveniles transferred to criminal court. For example, between 2021 and 2022, black juveniles represented 66% of the youth who were waived to adult court in Florida, compared to only 21% white and 12% Hispanic. Of the youth who were transferred to criminal court, black and Hispanic juveniles versus whites were much more likely to be sentenced to jail. Black juveniles in particular had the highest likelihood of being given a prison sentence, and their sentences were significantly longer. This data was analyzed to consider different variables like age and type of offense. Whatever the offense type, violence, sexual, or drug-related, research showed that Black juveniles are more likely to receive a sentence in jail or prison than white offenders. One study analyzed sentences received by youth and adult offenders who had committed felonies. Regardless of factors like prior experience with the justice system, offense type, and economic disadvantage, it found that transferred juveniles were more likely to receive a prison sentence and significantly longer than adults if the youth was from a county with a higher minority presence, and especially when there had been a recorded increase in minorities. This data is difficult to hear, but it exposes the layers of injustice in our system. It is critical to share this research so that we are conscious, that we are aware that racial disparities don't just sometimes happen. They are not isolated incidents of racial profiling, bias, and injustice. But it continues to be a systemic issue that must be eradicated for the criminal justice system to act in the best interest of pure justice. The question remains, what is justice toward children who commit murder, no matter their race, ethnicity, age, gender, and background? What does that look like? Of course, our society can't afford to ignore the violent actions of children, in particular homicide, because they may be considered lacking criminal culpability due to their young age. But how can we justify placing children into adult prison, along with some of the most dangerous and violent predators? How can we put them in isolation with the goal of protection during their most formative years? Every case must be considered on its own, as murders committed by an adult should be. The type of murder, if it was planned, the type of weapon and method employed, the mindset and regret or lack of remorse shown by the offender, and the environmental circumstances of their life. Each of these elements should impact the way our system treats a violent child offender. In the case of Curtis and Catherine Jones, they were not. These children were not monsters. They were terrified, traumatized, victims of severe sexual abuse, and they felt pushed to the edge. They felt that their lives and their welfare were being threatened, because they were. And no one believed them. No agency, no adult, no one would help them out of their situation, so they felt desperate. They felt they had no other choice but to kill the people who would not protect them. A child who stabs someone over 100 times versus a child who shoots someone in a moment of, whether it's rage or fear, is a different kind of violent offender. It can't be denied that both types of offenders need and deserve to have ongoing psychological care, but the penalty involved should be different. There must be dedicated resources and commitment made to prevent children from being manipulated by the system, which can lead to their entire young lives being destroyed. For juveniles in the prison system, they must be protected in spirit, mind, and body. They need to be constantly mentored and counseled so that if and when they are released, they can become positive, productive members of society. The question remains, though, what kind of murder should dictate a minor being adjudicated as an adult? Should there be a set federal minimum age at which a prosecutor can try a child as an adult, so 12 and 13-year-olds are not literally growing up incarcerated? What about the adults in their lives who failed them? Shouldn't they be held liable for their lack of care, abuse, and negligence, and have to face some form of justice? It can't be denied that Catherine and Curtis Jones are brave, strong, inspirational, and resilient individuals. What they endured as children, from being abused to being thrown into the system and forgotten about, is heartbreaking and infuriating. It is a testament to their character that it did not destroy them. Their story is important for all of us to know and share. Thank you so much for listening. I would love to hear from you about your thoughts on this case and your feelings about juvenile waivers in general. Should we be sending children to adult prison, no matter what the crimes they committed? If you have any thoughts, questions, ideas for future episodes, please reach out. You can find my contact information in the episode description. Until next time, stay safe and watch out for shades of murder happening in the streets next door, especially inside your own home. Shades of Murder is created, researched, written, and edited by Lena Caldwell. Original music composed by Stereo